Good afternoon, all. I'm Aditya Gupta, Senior Associate at Sagar Associates. We welcome you today to this session that will focus on helping industries reopen amidst COVID-19 pandemic. The session will be conducted by Mr. Anupam Varma, partner at Sagar Associates. The session was requested by Industries Association of Uttarakhand, that is an apex body of micro, small, medium, and large industries based in Uttarakhand. Mr. Pankaj Gupta is the president of the association, who is present with us today and would grace us with the opening remarks. Before handing over the session to Mr. Gupta, I would like to inform everyone that we will be taking your questions via the live Q&A box that appears on the right side of your screen. Please feel free to post all your questions in the box. They will be addressed by Mr. Varma at the end of the session. Over to Mr. Gupta.
Thank you, Aditya. Good afternoon, everyone. We, Industries Association of Uttarakhand, Sagar and Associates, the joint organizers of this meeting, which is being held through the virtual mode in the most difficult times through which we all are passing. Let me take this opportunity to thank Messrs. Sagar and Associates, and particularly Mr. Anupam Varma and his team, including Mr. Nikhil Sharma and Mr. Aditya Gupta, who have worked very hard to design and make this webinar possible. This webinar is an interactive forum for discussion. Besides other important issues, this webinar would concentrate on impact of COVID on industries, finance, marketplace, production line, manpower. Second, compliances as per third lockdown order, effect of non-compliances, best practices, and overall safeguards. Third, labor issues, payment of wages as per MHA guidelines. Fourth, contractual issues, force majeure, how to mitigate losses and how to use clauses in contract. Messrs. Sagar and Associates is a leading national firm in India with over 320 professionals operating out of 7 offices in India. JSA practices is organized along service line and sector specialization, and they focus on providing legal services to top Indian corporates, Fortune 500 companies, multinational banks and financial institutions, governmental and statutory authorities, and multilateral and bilateral institutions. JSA is recognized as a leading national law firm providing legal services to top Indian corporates and others. JSA serves clients across 11 segments of the economy, including agriculture, automotive, aviation, banking and finance, defense, education, hospitality, knowledge-based industries, telecommunications, manufacturing and consumer products, besides other gamut of activities. It is a pleasure that this session is being conducted by no other than Mr. Anupam Varma, partner Sagar and Associates, and is being ably supported by his team. Mr. Anupam Varma specializes in dispute resolution and issues relating to statutory approvals, licenses for businesses and corporates. Mr. Anupam has acquired special insight in advising on labor compliances, regulatory, policy and commercial matters related. He handles diverse legal and regulatory and policy issues. He has extensive experience from diverse fora including the Supreme Court of India, High Courts of various states, National Green Tribunal, Appellate Tribunal for Electricity, State Electricity Regulatory Commissions, and District Courts. Mr. Varma has advised several private utilities in electricity sector on diverse legal and regulatory issues, particularly on diverse aspects of electricity reforms and restructuring, besides other specializations. Now, without taking much of your time, I hand over the session to Mr. Anupam Varma. Welcome you, sir.
Thank you, Mr. Gupta. A very warm welcome to everyone on this webinar in these testing times. So we have chosen to provide this presentation on the challenges being faced by industries in the COVID-19 scenario. COVID-19 is a highly infectious disease caused by most recently discovered coronavirus. This new virus and disease were unknown before the outbreak began in Wuhan, China in December 2019. The WHO declared it as a pandemic on 11th March 2020. Even before the declaration of the pandemic on the 19th of February, the Procurement Policy Division of the Department of Expenditure, Ministry of Finance, Government of India, recognized that there is a disruption in the supply chain due to the outbreak of coronavirus, and it should be considered as a national calamity. Force majeure clauses were accordingly to be invoked where considered appropriate. To contain the spread and minimize the fatalities, the central and state governments of India have taken serious and strong action which has disrupted the commercial and economic activities. Thereafter, various advisories were issued to maintain social distancing by the central and state governments, including requests not to play Holi on 10th March. This is an unprecedented situation, and even the courts have been shut down in Delhi, in Dehradun, and the entire state of Uttarakhand since 18th of March 2020. Many Uttarakhand government offices also were directed to remain shut since 20th March 2020. On 22nd March, the Prime Minister appealed to the citizens to observe a Janta curfew. On 24th March, the Ministry of Home Affairs directed imposition of a complete lockdown in the country to help government authorities to deal with the pandemic. 3 successive lockdown orders of 24th March, 14th April, and 1st of May have been issued till date. Aditya, can I have the second slide, please? We would like to take you on an overview of the compliances which are involved in respect of the government directions, the guidelines and the advisories that have been issued from time to time, compliances and best practices. Thereafter, we'll be giving you an overview of the labor law issues dealing with legal enactments, government directions, guidelines, advisories, and proceedings before courts, and grounds of challenge which are available. The third leg will deal with the force majeure, and we would touch upon issues under the Indian Contract Act, the effect of force majeure, and some key takeaways. The presentation focuses on the impact of government orders. Firstly, compliances to be made by the industries during and post the lockdown period, including on reopening. Secondly, the payment of wages, and lastly, impact of force majeure on commercial and employment contracts. The analysis, I'm sure, would assist you in understanding the contours of the problem and get some clarity on the possible solutions. The governmental restrictions and prohibitions on movement of men and material, markets, and shortfall in liquidity has caused major losses across various sectors. The supply chain of raw materials and finished goods has been adversely affected. The interstate movement of cargo, which got affected on 24th March, is still to revive to normal levels. Limited movement of goods via road transport has led to goods with the estimated value of about 35,000 crores being stranded on the roads outside factories and godowns. Supply chain of products and intermediates which has been affected has also led to reduction in imports and exports. Heavy losses have been incurred by industries across all sectors, including those engaged in essential activities such as pharmaceuticals, herbal, agro products, food processing, and also non-essential activities like FMCGs. The entire production line has been affected as raw materials are not reaching manufacturing facilities. Unfinished goods are lying stranded in the production line. Finished goods are not reaching the market and consumers. Almost all industries have faced the problem of lack of maintenance of machinery and regular upkeep of the industrial units. The raw material to be utilized for production activities has deteriorated or perished, awaiting relaxation of restrictions. This problem has been faced by industries in the aluminium sector, in electronics, defense components, automobiles, and auto ancillaries. Now, I'd like to just touch upon the unorganized sector in India. The unorganized sector in India accounts for 93% of the workforce. After the announcement of the lockdown, the workers were caught unawares and, in absence of a safety net and panic, took flight homeward bound. Due to the abrupt closure of public transport, the reverse migration was mostly on foot. At first, these laborers were not allowed to cross interstate borders, and the central government also directed industries to make full payment of wages in an attempt to arrest this reverse migration. Now the laborers are being allowed to return to their home states, and many on free of cost trains which have now been started to transport these migrant laborers. The reverse migration of the workforce has left the industries unaware if these laborers will come back once industrial commercial activities are resumed. The real impact of the said problem will come to light when the industries start to resume operations. Shops and establishments in malls, in shopping complexes, in marketplaces have all been directed to close their operation after the lockdown orders, except those dealing in essential products. This scenario has led to a serious depletion in the demand, cancellation of orders, loss of market, leading to substantial losses for the industries. It has been estimated that there has been a total loss of upwards of 9,000 crores in the state of Uttarakhand alone. There is widespread uncertainty in the market as to how the economic activity will be allowed to resume. The payments in every industry are blocked, and even financially stable industries have started to conserve cash and not make payments for goods. This uncertainty has led to a depressed cash flow in the market. It is seen that financial conditions of industries has been impaired due to the dual burden caused by loss of revenue and mounting debts of the banks, wages and lease rentals. Many solvent industries are being pushed to the verge of insolvency. The RBI and the government have announced certain reliefs regarding the repayment of loans. However, these same are inadequate to meet the challenges being faced. The government is expected to release a stimulus package, the details of which are still awaited. We would now seek to dwell on the timeline of the guidelines. The lockdown orders and directions by the central and state governments are being issued under the Disaster Management Act 2005, the Epidemic Diseases Act 1897, and the regulations framed under them by the respective states. The chronology of the relevant orders is as follows. 15th March 2020, Government of Uttarakhand under the Epidemic Diseases Act framed the Uttarakhand Epidemic Diseases COVID-19 Regulations 2020. On 24th March 2020, first national lockdown order, which was to have remained in effect till 13th of April 2020. Thereafter, on 14th April, the second national lockdown order, which was to have remained in force till the 3rd of May, and various orders by respective district magistrates for compliance of the standard operating procedures, which were notified. On 1st of May, the third lockdown order was passed for a lockdown till 17th of May, which still continues. Orders were passed by respective district magistrates allowing some industries to reopen as per the Ministry of Home Affairs order and guidelines. Now, the laws and regulations passed in view of COVID-19, we have to understand that the genesis of these orders are the Epidemic Diseases Act 1897 and the Disaster Management Act 2005. The Disaster Management Act 2005 was constituted under entry 23 of the concurrent list of the Constitution of India to provide for effective management of disasters for matters connected and incidental thereto. I would like to highlight that there are offences and penalties which are provided under sections 51 to 60 of the Act for any infraction of the law. Section 51 to 54 provide the offences under the Act, which are for non-observance of orders or obstruction in discharging functions or false claims or misappropriation of money or material or false warning. The punishment of the said offences is also provided, and the same may extend up to 2 years. I may point out section 58 relates to offences by companies and places the person in charge of responsible to the company for the conduct of its business guilty of contravention of offence, and section 60 deals with cognizance of these offences. The Epidemic Diseases Act 1897 is an act to provide for better prevention of the spread of dangerous epidemic diseases. It is a short act comprising just 4 sections. However, the act provides for substantial powers to the state governments to frame measures, regulations to prevent outbreak of diseases or the spread thereof. The regulations framed under the act can contain as they do directions to be followed by the public and any person or any class of persons. Non-compliance of the regulations and provisions may attract penalty under section 188 of the IPC. Uttarakhand has passed the Uttarakhand Epidemic Diseases COVID-19 Regulations 2020 dated 15/3/2020, wherein under Regulation 16, the orders passed by the central government with respect to COVID-19 have been made mandatory. The plain reading of the orders and guidelines would show that orders of the Ministry of Home Affairs and the Labour Department are binding and have to be strictly followed. The orders are passed in the background of an unprecedented life-threatening disease. The same cannot possibly be taken lightly or ignored. Commercial considerations for the time being have to be subsumed, and every individual has to take equal part in fighting the disease and making the situation normal. A reading of the Act shows that the district magistrate's order cannot be in violation of orders which have already been passed by the Ministry of Home Affairs. The district magistrates can prescribe for additional guidelines but cannot contradict or relax existing guidelines of the Ministry of Home Affairs. On 15th of March 2020, the Uttarakhand Epidemic Disease COVID-19 Regulations 2020 were notified, wherein Regulation 16 provides that all advisories issued or to be issued by the Government of India on COVID-19 will ipso facto be treated as directions under this Act regulations in the state of Uttarakhand. The Chief Secretary of the state of Uttarakhand invoked the Epidemic Diseases Act 1897 and directed lockdown in the state from 22nd of March 2020 till 31st March 2020 and requested that the industries and other commercial establishments were not to deduct wages of the workmen. The District Magistrate of Dehradun issued a lockdown order dated 22nd of March 2020 under the Uttarakhand Epidemic Diseases COVID-19 regulation, directing that all public transport, restaurants, hospitality and tourism activities, central, state and private offices in the state were to be closed except for essential services. On 24th of March 2020, the Home Secretary, Ministry of Home Affairs issued the first lockdown order and guidelines, which remained in force for a period of 21 days from 25th of March, that is till 13th April 2020. In terms of the guidelines, the offices of the central government, its autonomous subordinate offices and public corporations in respect of power generation, transmission would still remain open. The offices of the state UT government, their autonomous offices and corporations in respect of electricity would remain open. Commercial and private establishments in respect of power generation, transmission and distribution units and services will remain open. all industrial establishments except manufacturing units of essential commodities and production units which require continuous operation after obtaining permission from the state government were to have remained open. Wherever the exemptions have been allowed, as in the case of electricity, the employer must ensure precautions against COVID-19 and social distancing as advised by the health department. The restrictions fundamentally relate to movement of people, but not to that of essential goods. Order dated 14th of April and guidelines were issued by the Ministry of Home Affairs by the second lockdown order, which extended till 3rd of May 2020, and it was directed that there would be strict compliance of the activities. Certain commercial industrial establishments were allowed to operate with certain conditions, and restrictions as per the standard operating procedure were provided with the guidelines. Penalties for non-compliance were mentioned, which include Section 51, as I mentioned earlier, 51 to 60 of the Disaster Management Act and Section 188 of the Indian Penal Code. Some of the mandatory compliances under the standard operating procedure were disinfecting of entrances, cafeterias, meeting rooms, conference halls, open areas, lifts, equipments, washrooms, walls, vehicles entering the premises, etc. Transport facility for workers to be arranged, and mandatory thermal scanning of everyone entering the workplace. Medical insurance of the workers was made mandatorily, and this is very important. Provisions for hand wash and sanitizers with touch-free mechanism at all entry and exit points. Ensuring social distancing of the workers and maintenance of gap of 1 hour between shifts and staggered lunch breaks. Ban on non-essential visitors on the site. Nearby hospitals that treat COVID-19 to be identified, and a list was to be made available at the workplace. In Uttarakhand, more than 10 orders have been issued for relaxation and implementation of the MHA guidelines. The said guidelines were not conducive to opening of industries, as the same prescribed very stringent methods of opening up of industry, and most of the industries were unable to meet the requirements, and hence they remained closed. The Ministry of Home Affairs thereafter has now issued an order dated 1st May 2020, extending the lockdown measures from 4th of May till 17th of May 2020, along with new guidelines on the lockdown measures under Section 10 of the Disaster Management Act. This was the third lockdown order. The new guidelines, which are now in force, override the previous guidelines and give a number of relaxations as compared to the previous guidelines. The same have come into effect on 4th of May 2020, and it has been clarified that the previous approvals and permissions granted by the local authorities shall continue to be in effect till 3rd of May 2020. Para 10 of the guidelines specifically states that activities not prohibited are permitted. However, ample discretion has been given to the states and union territories to place additional restrictions as they deem fit based on their assessment of the situation. Individual states and union territories and districts by the subsequent guidelines have to determine the actual restrictions to be put in place by each state, union territory or district. Following the said directions by an order dated 5th May 2020, the district magistrate in Dehradun has allowed all industrial activities to operate as per the MHA guidelines. And in light of the new guidelines, the compliances to be made by industries to reopen are, and I will just illustrate some of them. It is to wearing of face cover is mandatory. Adequate stock is to be made available by the establishment. Social distancing is to be observed as per the Ministry of Health and Family Welfare guidelines. Adequate gaps between shifts and staggered lunch breaks for staff provision of thermal scanning, hand wash, and sanitizers, preferably with touch-free mechanism at all entry and exit points and common areas, frequent sanitization of workplace, common facilities, and all points that come in human contact. Persons above 65 years of age and persons with comorbidities, pregnant women not allowed to work. Use of the Arogya Setu has been made mandatory for all employees, head of the organization, to ensure 100% coverage. This is noteworthy. Large physical meetings are to be avoided. Transport facilities with social distancing is to be ensured. Intensive communication and training on good hygiene practices has to be taken up. Hospitals authorized to treat COVID-19 have to be identified, and a list has to be made and kept ready and available at the establishment. Employees with symptoms have to be taken immediately for checkup, and there is a protocol for this. One has to have quarantine areas to be earmarked for employees showing symptoms. The Disaster Management Act, I may add, is a social welfare legislation and has been passed under entry 23 of the concurrent list of the Constitution of India. However, it cannot be treated at par with a tax or a financial legislation, and has to be interpreted in the widest manner possible. Section 10 of the Act provides that directions can be passed to mitigate economic hardship. A reading of the Act would show that it is only limited to allow the central government to work in coordination with the state governments to prevent the control of the pandemic. The same cannot be used to direct private individuals to part with their property and slide into insolvency. However, it needs to be kept in mind that the individual states, including the state of Uttarakhand, have passed regulations under the Epidemic Diseases Act, wherein they have specified that the guidelines and advisories issued by the central government shall be binding. Accordingly, if it is to be presumed that the central government had no power to issue directions under the Disaster Management Act, the states, by adopting the directions, advisories, and guidelines, have made the same legally binding and applicable to the states that they have been made applicable to. There is non-compliance of the compliances would lead to penal consequences under section 51 to 60, as I had earlier mentioned, under the Disaster Management Act and section 188 of the IPC. The individual directions, as far as a challenge to the directions is concerned, individual directions can be challenged by specific industries by demonstrating their hardship to follow the mandate of the grounds on the grounds of arbitrariness, treating, for example, treating unequals as equal, and on the ground of proportionality, that it has an effect which is far in proportion to what the cause is, and sending a solvent company into insolvency by directing private organizations to part with their property. However, I may only mention that any challenge to these directions will be strenuously contested by both the state government and the central government, because they, on their part, would be entitled to argue that under the present unprecedented circumstances, such directions are imperative. However, in case there is any genuine difficulty by any industry or a group of industries in adhering to any of the prescriptions of the orders and the guidelines, the specific industry can seek a relaxation by representing to the appropriate government or department. But I may add, for this, it would be extremely essential to show that even without meeting the compliance, the mandate of the guidelines is met and there is no compromise on the health and safety of the persons involved. That that is non-negotiable. For example, unavailability of thermal scanning equipment, disinfectants, sanitizers, masks, gloves, etc. The establishments had to stock were actually uh, charging exorbitant prices. And as such, representation could be sent to the Ministry of Home Affairs or to the state government stating that the compliance can be made by alternate means without compromising on safety. But this would have to be taken up on a case-to-case case basis. Um, Now, if I can draw your attention to some of the best practices which are to be followed in order to limit the spread of the disease and for reopening of operations. Uh, 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 all possible measures to protect the health of employees and vendors have to be taken by industries and establishments. So, in order to minimize the threat, we would suggest that industries ensure that the spread of the disease is contained, and it is actually in everyone's interest that no one is contaminated by the disease. Therefore, industries need to follow best practices and ensure that post reopening of operations, all possible measures are taken to protect the health of employees. The industries need to take control of transport to a particular site or establishment, on the site and for off-site activities, for common areas, for offices, for the shop floor, for visitor management. This will ensure that areas that are under contact by workers are reduced. This may have the beneficial effect of reducing the spread of the virus and help protect the health of the industry. Industries may also consider giving guidelines to the workforce on allocation and social distancing, and consider feasibility of operating at a reduced workforce strength on a rotation basis during this period. This would actually meet the objectives of social distancing, and so that it provides for a minimum congregation of employees. Uh, the guidelines can also include that employees should mandatorily be required to carry their employee identification cards and permission to enter the premises on their person at all times. Establishments should restrict the entry of visitors and vendors on site. Where visitors and vendors are required to supply any essential material, services, or their entry is critical to the operations, such entry should be documented, and the visitor should be required to undertake the health and sanitation precautions which are listed, and prohibit the entry of any visitor, vendor, employee who exhibits any symptoms of COVID-19 or has a history of international travel for a period of 14 days prior. Uh, uh, One of the steps that can also be taken is reduction in the number of shifts to reduce the contract labor entering the premises. It may require vendors to ensure that their contract workers are not showing symptoms or not exposed to COVID. To promote social distancing, the industries may also consider offering remote working options to employees wherever possible. In order to enable this remote working, we suggest that, amongst others, industries should ensure that the requisite IT software and hardware is in place to enable employees to remotely access servers. identify employees who are operationally critical to be present at various offices and field locations, and those who can work from home. Establishments, industries can even consider migrating computer desktops, laptops, and other hardware for certain employees who can work from home. This would minimize the disruption in the event that the industry is required to on account of an affected employee, weak visitor or otherwise, or in the unfortunate eventuality of keeping its offices closed for a period of time, as may be directed by the government. You know, the establishment can also undertake essential correspondence on official email and avoid physical dispatch of documents to other offices to the extent possible. Conduct meetings to the extent possible only by video conferencing. Further, the frequency of meetings may be reduced to only necessary meetings. Provide comprehensive information and guidance to employees on, among other things, reporting lines, work hour, expectations, and time logging. Further, every employee should be required to take approval of their designated manager for working overtime. This in these hard times, this would be a very crucial step in managing the workforce, and would also be helpful on the bus. There would also be requirements to review existing policies on permissible reimbursements to employees, to allow reimbursement of necessary work expenses up to certain predetermined limits. So if you predetermine limits, you are able to limit your expenses. These can normally be related to work-related calls, stationery, internet access, etc. to employees working from home. One other crucial aspect is that the businesses and industries would have to update their privacy policy if necessary, to ensure that any company confidential data which is stored or processed on personal devices of employees and is accessible to them is in safe hands. Requisite IT personnel would be available to work at regular hours to resolve any concerns and to ensure continuity and smooth functioning of the IT infrastructure for this remote working. From this crisis, we have learned that there is a requirement of an effective emergency preparedness and response plan, communication and awareness plan to deal with such emergencies. Such plans should be prepared based on the size of the industry. The communication, compliance and development of such plans should be ensured by designating an officer along with a quick response team for that particular establishment or office. For effective communications of the action items of the plans, office orders can be issued, and we can help in preparation of such office orders. In order to see any shortcoming of the plans and to deal with the ever-evolving situation as it is, the conformity of health and safety procedures should be regularly evaluated by hazard identification and risk management. For this, professionals can be inducted, or a professional agency can be engaged by industry. For proper implementation of the plans and to give effect to the protocols, the workers need to be sensitized and trained regarding the disease itself and its spread. Help of accredited professional agencies may be taken in respect of training of workers. We would like to suggest that all employees and contract labor should be advised on general health and hygiene and can be cautioned to monitor any symptoms. For this, uh, specifically, we can suggest that businesses and industries can display notices, posters, pamphlets, providing for information for prevention and control of COVID-19 at prominent places throughout the various offices. Provide all employees, both on-site and employees working from home, training and awareness material as may be made available by the Government of India to take care of their own health and look out for any respiratory symptoms, fever, etc. Ensure that employees who are not feeling well leave the workplace immediately after informing their reporting officer. Can require employees both on-site and employees working from home to promptly notify their reporting officers if they or any member of their household has been tested positive for COVID-19. Such employees should also be required to isolate themselves and observe self-quarantine, and consider providing all employees a list of standard operating procedures and contact numbers to report any health emergencies. Now, workers or employees should also be made aware that any person violating any self-quarantine directions received from the health department under the lockdown order, upon being diagnosed with COVID-19, may be liable to be proceeded against under the Disaster Management Act, or he may even be liable to criminal proceedings under the Indian Penal Code. The workers or employees should therefore be strongly advised as to the statutory liability for violation of the lockdown order. Further, employees violating the company policies implemented in relation to COVID-19 may, subject to the terms of the company policy, be proceeded against for workplace misconduct. Apart from training workers, it is also essential to ensure that workman compensation and medical insurance has been taken for the workers, if not already covered by ESIC. Based on our review of various guidelines issued by the health departments across different states, we note that general advisory has been issued in relation to health and sanitation measures to prevent COVID-19. We have identified certain best practices which, in our experience, are being implemented across various organizations to prevent COVID-19 at the workplace. These are, amongst others, to promote cleanliness in the workspace and educate staff about its importance via meetings or announcements, placing of hand sanitizers at entry points, exits throughout the offices, proper and frequent cleaning and sanitization of the workplace, particularly of the frequently touched surfaces, the regular supply of hand sanitizers, soap and running water in washrooms, and disablement of biometric systems and implementation of contactless systems to monitor access and attendance. This may have a technological aspect to it, but the demands of the times we are living in requires this, and this may entail some amount of expenditure as well. Now, employees are to also ensure wearing of proper masks, gloves, head covers, and body suits in processes where they may be required to do so. There is also a need to install temperature screening equipment and mandate all persons requiring the office premises to pass through such screening. Further, industries may also consider requiring any employee who exhibits flu-like symptoms to undergo medical tests. It would also be pertinent to note here that regarding that any data regarding a person's health will qualify as sensitive personal information under the Information Technology Reasonable Security Practices and Procedure and Sensitive Personal Data or Information Rules 2011, which are the privacy rules which have been framed under the Information Technology Act. Therefore, if any such screening is implemented by a business or an establishment, industry should ensure that the employee consents are in place to collect such data through such screening activities. And it may also be noted that visitors, vendors who are required to enter the office premises but are not employees, industries may permit such visitors or vendors to enter the premises after obtaining a written declaration form duly signed and dated by the visitor, permitting the industry or the establishment to screen, collect data and store data on the visitor's health as obtained through the screening process. You may note that any data so collected of the employees or of the visitor, as the case may be, will need to be encrypted and stored in compliance with the reasonable security practices prescribed under the privacy rules. You may also prepare a chart and database to record compliances on a regular basis. Yeah, can we have the next slide, Aditya? So now we bring you to the contours of the labor issues which are involved in this scenario, and the heads mainly are the legal framework, which are the directives and the provisions. Secondly, the list of compliances, consequences of breach and mitigation. Thirdly, the legal issues and the way forward. So in this section, we shall deal with the issues arising in context of payment of wages to labor. We will discuss the legal framework, the list of compliances, legal issues and the way forward. Now, under the Payment of Wages Act, Section 2, read with Section 9, provides that deduction from wages is allowed in case of absence from duty from the place where the employed person is required to work and during the period he is required to work, that is, absence on his own volition. Secondly, the Industrial Disputes Act under Section 25C, small establishments are allowed to lay off workmen upon paying 50% of basic wages and dearness allowance for a period of 45 days. So, if I were to explain, words and terminology which have been used in the orders of the government, like workmen and wages, are not defined under the Disaster Management Act or the Epidemic Diseases Act, and as such have to be given the widest meaning. The Payment of Wages Act defines workmen and wages in the widest manner, and for the purpose of the orders, we are actually borrowing the said definitions. Wages as such would mean the salary and other components also, and workmen would mean the persons following under the Payment of Wages Act. In this discussion, we shall be dealing with the words and terminologies defined under the Payment of Wages Act 1936 and the Industrial Disputes Act. There is no need to go in detail in this discussion with regard to the said enactment, and the industry is well aware of the impacts of the same. In case it is required, we can have a separate discussion for these enactments. Now we deal with directions by the government. Now the central government and the government of Uttarakhand have given their directions. And since the imposition of the lockdown order, the central government has taken various steps to minimize the impact of the lockdown on the economy. One of the major issues which were before the government after the imposition of the lockdown was to ensure that citizens are not impacted due to the closure of economic activities. There was a need, consequently, to ensure that salaries are being regularly paid. One of the first steps which was taken by the Department of Personnel Government of India was on 17th of March 2020, whereby it issued an office memorandum inter alia advising employers to sanction leave wherever any request is made for self-quarantine as a precautionary measure to all employees who are at higher risk, that is older employees, pregnant women, and employees who have underlying medical conditions to take extra precaution. And ministries and departments may take care not to expose such employees to any frontline work requiring direct contact with the public. Thereafter, on the 20th of March 2020, the Ministry of Labour and Employment, Government of India, issued a communication to all chief secretaries, wherein, amongst other things, it directed that all employers of public private establishments may be advised to extend their coordination by not terminating their employees, particularly casual or contractual workers, from job or reduce their wages. If any worker takes leave, he should be deemed to be on duty without any consequential deduction in wages for this period. Further, if the place of employment is to be made non-operational on account of COVID-19, the employees of such establishment or unit will be deemed to be on duty. Following the above communication, various state governments issued notifications, advisories invoking the provisions of the regulations under the Epidemic Diseases Act, and directed the private establishments to follow the advisory of the Ministry of Labour and Employment. Thereafter, the first lockdown order of 24th March was passed. After the first lockdown order, the government came across the humongous issue of migrant labourers in the unorganized sector of the economy. The unorganized sector was left without jobs or salaries, and this led to a huge migration by them to the state of their origin. However, due to the closure of public transport, most of them undertook, unfortunately, the journey on foot. To combat the issue, on 26 March, a relief package was announced by the Finance Minister to shield this poor segment of migrant labour. However, the same did not stop the migration. In another attempt to combat the issue, on 29th March, the Ministry of Home Affairs issued an order to deal with the situation of movement of a large number of migrants and for effective implementation of the lockdown measures, and to mitigate the economic hardship of the migrant workers. It was directed that all employers, be it in the industry or in the shops and commercial establishments, shall make payment of wages of their workers at their workplace on the due date without any deduction for the period their establishments are under closure during the lockdown. So this has wide ramifications for the audience that we are addressing, and we would deal with this subsequently as well. Then directions which were passed by the state of Uttarakhand on 29th of March. By a letter, the Chief Secretary of the state of Uttarakhand to the district administration of all the districts instructed that the mandate of the order dated 29th of March would be followed, and the following orders were passed in this regard. Now, the order of 30th March 2020 was by the District Magistrate of Dehradun directing payment of wages without any deductions. Then there was an order of 31st March 2020 by the Labour Commissioner, Government of Uttarakhand, directing that the order dated 29th of March 2020 will also apply to contract labour. Then there was this order of 3rd of April 2020 by the Labour Commissioner Uttarakhand, directing that for the absentee workers in the essential industries, the deduction of wages shall be effected as per normal conditions. Now, I would like to bring you to the proceedings which have been instituted before the Supreme Court and in some states in challenge to these central government directions. Now, various proceedings have been filed by associations of industries challenging directions of the Ministry of Home Affairs. However, till date, the courts in the interim have not interfered with the directions of the Ministry of Home Affairs, and the directions therefore are binding and have to be complied with for the present. The only limited relief that we have come across is in Maharashtra, where the Honorable Bombay High Court, by an order of 30th April 2020, passed in a batch of writ petitions. It directed that where the industries have been allowed to reopen and the workers remain absent, the management would be at liberty to deduct their wages for their absence, subject to the procedure laid down in law while initiating such action. This would apply even to areas where there may not have been a lockdown. Now, as far as the grounds of challenge are concerned for challenging the directions of the Ministry of Home Affairs, there are certain grounds which we have listed out. First amongst these, if you can see on the slide before you, it is violative of Article 14 of the Constitution of India, that is treating unequals as equals. Secondly, it is violative of Article 19 1G of the Constitution of India. The orders, advisories only cater to employees, and if guidelines, orders, advisories are implemented, many employers will face insolvency. Whether salary is a property under Article 300A of the Constitution of India, the employers have actually argued that government could not have directed private individuals represented by the businesses and industries to make payment of salaries in violation of Article 300A. The Kerala High Court has recently held that deferment of salary amounts to violation of Article 300A. Now, fourthly, ultimate responsibility of the state is to protect both the employers and the employees. And in this context, the state should not be seen to have shifted its welfare burden to protect employees onto the employers. And lastly, the directions passed by the Ministry of Home Affairs are arbitrary and they are unreasonable. So in conclusion, as far as a challenge to these directions are concerned, at this stage and for the present, we can only say that till such time that the directions are not set aside or varied, the same will have to be complied with. Payments to service contract vendors cannot be stopped by businesses, establishments and industries. Principal employer has been required to ensure payment of wages to the workforce engaged by the vendor, that is the contractual workforce, and failure to abide by the directions issued under the Disaster Management Act would lead to strict penal consequences. However, there is a via media that relaxation can be sought. So, as is evident it is essential for industries to comply with the directions issued by the central and the state government. The payments to even service contract vendors cannot be stopped, as it would lead to non-payment of wages and other emoluments to the workers and industries. There is no mandatory direction on industries to make full payments to its vendors. The only obligation, if I may point out, is to ensure that payment of wages to the workforce. Industries can restrict the remittance to the amount which pertains to wages. However, this may create issues with the vendor per se, if there are subsisting contracts with the vendor. Industries can so restrict the remittance to the amount which pertains only to wages. Any failure to abide by the direction under the Disaster Management Act would lead to penal consequences. One word of caution that I would like to highlight here is that industries, businesses, and establishments should actually ensure, verify, and cross-check that payments that are released by them to the vendor, which are in turn payable to the workforce without any deductions for the period of the lockdown, are as per the earlier time frame. So, because as the principal employer, the onus of ensuring that the payment reaches the beneficiary remains with the principal employer. Although there may be contracts with vendors, but the onus would lie with the principal employer. So having wrapped up this discussion on the scenario as far as the labor law aspects are concerned, I would now like to take you to the concept of force majeure and the effect on performance of obligations and on payment obligations. So we need to understand the concept in the present scenario to appreciate the contractual and commercial obligations under a business agreement. We will be discussing the ingredients and the effect of force majeure in the present scenario, and we can discuss the concept in greater detail if required in any subsequent discussion. So the meaning, the basic concept and ingredients of force majeure are: force majeure is a Latin term meaning superior force. It can be defined to be an event or circumstance or combination of events and circumstances which materially and adversely affect the performance of the obligations of either party to a contract and is not within the reasonable control, directly or indirectly, of the party affected. So the event is unforeseeable and beyond the reasonable control of any party. The event adversely and directly affects the party's ability to perform a particular contract, either fully or partly or in a timely manner. The disability must be such that the object and purpose of the contract is lost. So the event may be natural or man-made, but the implications of both the events is different, and therefore utmost care has to be taken to identify a force majeure event as a natural or a man-made event. It is of extreme importance that we should examine that the terms of each contract and the nature of the event need to be analyzed in the facts of that contract and the context. Now, the ingredients of force majeure, which have generally been laid down by the Supreme Court in a seminal case law, which is Energy Watchdog versus CRC, is occurrence of an event which affects a party's ability to perform a contract either in entirety or in a timely manner, is beyond the reasonable control of the parties, and may not render an act to be literally impossible, but an act impracticable and useless in terms of the object and purposes of the contract. Difficulty in performance of any obligation under a contract is not sufficient for invocation of a force majeure provision. Also, there is this element, and this may ring true in a number of contracts across various industries, is that temporary disability to perform the obligation under the contract. Now, the event of temporary disability to perform the obligation under the contract can be dealt under Section 55 of the Indian Contract Act, which is the effect of failure to perform at a fixed time in a contract in which time is of the essence. Now, what is the effect of force majeure? Effect of force majeure is affected party not in breach. There is a suspension of obligations. There may be an effect on payment obligations, and termination. Now, the legal concept of force majeure generally leads to rendering a contract void. That is, I mean to say, it actually discharges the parties from any obligations under the contract. Any action done under the contract, including any procurement, etc., would be of no consequence. Though these days this term is being used very often, but we would like to caution the audience here that there cannot be any general use of this term. In case where the contract provides for what has to be done in a circumstances which are beyond the reasonable control of the parties, the terms of the contract will be implemented. And courts in India have consistently taken the view that efforts should be made to perform a contract, and the provisions of the contract must be so applied that the parties to the contract are liable, are able to discharge their obligations. Even if the result of a pandemic is specifically not mentioned in a force majeure clause of the contract, it is arguable that the effect of the restrictions would in no manner make the contract void. That is to say that even if there is no mention of a particular pandemic or an epidemic in a contract, the effect of it would be that the restrictions would in no manner be liable to make the contract void. In cases where it is stated that it is impossible to perform the contract due to force majeure or act of God, then the contract itself would become void. In such cases, there will be no liability arising under the contract, but any party receiving any benefit under the contract would have to make payments for the same. Only in cases where the force majeure event has affected the fundamental basis for the purpose of the contract, only then it is advisable that the concerned party evaluates and considers and weighs its options of invoking force majeure so as to make the contract void. So extreme caution has to be exercised if a party were to invoke force majeure, and it cannot and should not be invoked lightly. Now, we would like to take you through certain learnings which can be taken as takeaways from this ongoing crisis, and we would advise that that industries and businesses and establishments can do some business continuity planning. You can revisit existing business planning in light of the existing situation, reevaluate, reassess. You need to focus on liquidity and cash flow management. There can be initiatives to adopt technology and invest in R&D. In that sense, this pandemic also opens up opportunities for adoption of technology. You need to expand existing offerings and identify new revenue streams. You need to invest on risk management practices, not just restricted to the financial sector. You need to focus on the local market and area skill development, and one can take steps to find vendors and have localization of your demand and supply. You can increase avenues of digital commerce, and for the tough and hard choices that industry is facing, I think our suggestion would be some amount of policy advocacy needs to be done in these testing times. So it is essential to continuously reassess problems in the ever-evolving circumstances and make representations disclosing difficulties and seeking support from the central government. The central government is coming out with a stimulus package. It is expected that MSMEs will be at the forefront of these benefits. Representations with supporting data should be made available, and this would enable the central government to account for the data and give substantial benefits, and it would help in focusing and pinpointing where the benefits should actually go, and this would help in devising strategies. Further, the MHA compliances which are required, GST, tax rates, fuel prices, and a host of other relaxations can be sought, which can be industry specific, and where industries are facing genuine difficulty in implementation. As far as the state government is concerned, representations can be made to authorities for seeking exemptions by showing genuine financial difficulties. Apart from this, many state governments like in UP and Madhya Pradesh have given various benefits to industries with respect to labour laws. Representations can be made to the state government to allow similar dispensation and reliefs in the state of Uttarakhand. The state financial corporation can be represented to, and industries in their own individual capacities can seek reduction in the interest and allowing for additional finance based on viability of the business and for a moratorium, etc. There are these industrial development corporations which can be represented to, and appropriate and suitable reliefs crafted for industries specific focus can be sought. For example, as far as lease rents are concerned, their reduction or deferment. Similarly, electricity regulatory commissions across the country have given a number of reliefs to electricity consumers. And for example, in Delhi, the consumers have been allowed a moratorium on the fixed charges. There has been an extension of the due date of payment of the bill. There has been a reduction in the rate of the late payment surcharge. Similar reliefs which can be crafted and devised can be sought for from the Uttarakhand Electricity Regulatory Commission, and we would be happy to help you design that. Now, representations can also include support for specific industries or sector-specific stimulus packages. Then we come to adoption of best practices, which I have already taken you through in my earlier slide. This would help in minimizing the impact of the health and safety issues which employees and establishments may face. This would also bring in the element of ensuring proper excuse me, proper healthcare planning. And of course, lastly, focus on the force majeure clauses in the contract. Each industry or unit or establishment would actually need to revisit their existing or old contracts and add safeguards in new contracts to ring fence themselves. So I would now be happy to address any questions that you may have.
Thank you, sir. I've received 3-4 questions from people. One is regarding the force majeure. They mentioned we have a industrial development authority by the name of SITCUL in Uttarakhand, and basically many of the industrial areas have been developed by these by SITCUL, and the total land area is on lease. But none of the lease deeds have a force majeure clause in it. And can we now invoke it? Because during the month of April throughout, we were all locked down and the industries were closed, and only essential industries were allowed to function. So can the non-essential industries invoke this clause, as far as, since the lease deed agreement doesn't carry any force majeure clause in it? One. So should I take all the questions and then you'll answer, or should we go one by one?
We can go one by one, and I would be happy to address. Now, a lease is a concluded contract, and by invoking a force majeure, do you want to jeopardize the whole lease? If that is not the case, I think it would be a good idea to engage in a dialogue and enter negotiations with the authority and represent to them. They may even come up with a solution for you, because it is because of a situation which is beyond the control of the parties. The contributory factors are such that no mitigation could even have been done by industries which are in the non-essential sector, so to say. So as a first step, I would like to advise, engage in a dialogue and try and renegotiate. because it is ultimately a temporary disability.
Mm-hmm.
And as I said that invoking force majeure is not a is something not to be taken lightly, because then it can go to the extent of rendering the entire contract void, which we don't want. So I hope that answers the question. And to advise on such aspects, it is most important, from a legal standpoint, to examine what are the clauses of the lease. Are there any mitigating clauses? Are there any relaxations which are provided in the lease? Because there are both representations and warranties and covenants which the parties agree. So it would be helpful to examine those specific leases in order to be able to advise.
So another question that I've received: trade, businesses, and industries have to pay their April salary. Like you also mentioned, it is mandatory and legal binding on us. Do we have the option to legally stagger it by paying 50% of the salary at present and the balance in few upcoming months depending upon the liquidity?
Uh, the direction is for payment of wages.
Yes.
Now, in a strict sense, if one were to answer, the payment of wages for a particular month, if you are trying to ask whether the wages for the month of May can be staggered by paying 50% upfront and the rest of the balance 50% to be staggered in the following months, then there is an issue, because it says that wages would have to be paid. You may not pay certain other emoluments which go along with wages, but wages have to be paid. And if you want to enter into an arrangement that you want to defer it or stagger it, I think if there is a union, uh, the the workers can be taken into confidence, and it would need to be seen whether a settlement on this aspect can possibly be arrived at, because the risk is if a section of the workers agree to it and there is another section which may not agree to it. So the problem will be posed by those who do not agree with it, who may challenge it, and there may be litigation on account of that.
I think there are some published questions also, sir. Would you take them
Yes.
later on, or how are you going to take them?
Yeah.
I'll just read them out, sir, for you.
Yeah.
So one of the questions is, sir, is it mandatory to pay full salary if work from home is opted by employee in lieu of work from office?
Look, work from home is not a holiday, so to say. The employee is required to work from home. He'll be required to work during the working hours. But I have a counterpoint. Where is the rationale for paying lower salaries?
Right.
So is there a rationale for paying lower salaries, or is it a question of deferment of the salary?
So in this case, I think they're asking if they can cut the salaries in case of work from home. Is it?
That I think if it's a private establishment, it would depend on the private contract entered by that particular employee. if there is a contract, because if it's a CTC employee or a private employee, what were his terms of engagement? What were his conditions of service? All that will become relevant.
Right, sir.
So there cannot be a generic answer to that. So that would depend on the specific contract that the employee has with his employer.
Yes. So one other question is, please suggest some good practices for manufacturing MSME unit.
What kind of practices?
Best practices.
Best practices. We in slide 10, we have provided for the best practices post reopening of operations, and the need to undertake all possible measures to protect the health and safety of the employees and vendors. And it is fairly exhaustive, and if need be, we can share a more exhaustive list, because there are guidelines and there are compliances which need to be adhered to, because if they are not adhered to, then there are consequences in law.
So can this slide be shared with the members if provided to us?
I beg your pardon, sir?
Can this slide be shared amongst our members if it is provided to us?
Yes, we can surely share this with you.
Thank you.
So one of the questions is, in case the contract or lease expires during the lockdown period, what are the legal ramifications for the same?
If it expires, there is what you call what is the arrangement between the parties. A fair interpretation would be that an agreement which has lapsed during the period of this pandemic and during the period of the lockdown, parties by their conduct may agree to perpetuate the agreement till such time that they are able to renegotiate and re-execute a fresh agreement. But rights and obligations during the period would continue, but it also depends as to what kind of a contract it is.
Right,
whether it is a contract for occupying a property, that is a lease, or is it a commercial arrangement. The kind of contract would be of utmost importance in order to address this.
Thank you,
because,
sir.
Because the contract, because the wordings of the contract would also be relevant as far as this is concerned.
Yes, sir. Thank you, sir. I think we've exceeded the timeline by some minutes, so I'm
happy to answer any other queries that the members may have.
I'll just check, sir.
Sir, I'll pick up all the queries that the members have and mail them to you and Aditya so that we can have a response from your side, sir, on those.
Certainly.
So one last question that I may just add here: can landlords ask for rent for commercial establishments given on lease?
So I have a counter question. Is there a force majeure clause?
So we may assume for both the scenarios, sir, because there's
No,
the
so if in a lease there is a force majeure clause and it specifically says that during a force majeure event, which is beyond the control of the parties, the payment of rent would be suspended, then it would have to abide by that clause. If there is no clause, the practical answer to that would be, please negotiate, initiate dialogue and discuss, because it's the practical aspect has been that landlords and tenants have actually and I have first hand knowledge of that they have actually sat across and sorted out the issues, because this lockdown and the pandemic, this is going to uh, 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 create a lot of avenue for litigation, and litigation actually needs to be avoided. Although I'm a lawyer and I'm a litigating lawyer, but litigation has to be a last resort. What businesses and establishments, industry has to be mindful of is, please please ensure that you are complying with the law. Please ensure that you have put in place the uh, uh, the workplace protocols, that you have uh, that you have taken care of the safety and health of your workers. That would be a great service to business continuity, because disputes would arise, and there would be some of the disputes would have to go to court. But to the extent possible, I think we should avoid taking matters to court.
I think, sir, let me take your last word, avoid disputes. And on behalf of Industries Association of Uttarakhand, I would like to thank you and compliment you, sir, for giving us such an exhaustive and such informative presentation during the session. I think it's going to really address a lot of confusions that were there in our minds and will help us to move forward. So, once again, I would like to thank you and your team for such a beautiful session that has been organized by you, sir.
Thank you so much.
Thank you, Anupam, sir. And thank you for all the attendees for participating in the session. If you have any more questions, you can connect with the speaker on the email, which is available on the screen. Thank you and stay safe.